Moment. Just waiting for 5 minutes past the hour. I think we'll start. It gives great pleasure, ladies and gentlemen. It gives great pleasure to introduce Professor Ceballos. Professor Ceballos has been having a busy day today. He arrived at 9 o'clock. He attended my seminar on private international law from 9:30 to 1:30, to 9:30 to 12:30. From 12:30 to 1:30 we've looked for lunch. 1:30 to 4:30 attended a seminar on unjust enrichment. And now at 5 o'clock he's delivering his seminar on civil and criminal justice reform in the Philippines. So he's had a busy day. He's not here in Hong Kong for a very long time. He's in fact leaving Hong Kong for Macau tomorrow to, I think, watch Cirque du Soleil. But it is a great pleasure that he's taken time, whatever limited time he has in Hong Kong, to spend one whole day with us here in the University of Hong Kong. And we welcome Professor Ceballos, and we look forward to his thoughts on reform in the Philippines. Professor Ceballos.
Thank you, Professor. Thank you, gentlemen, for being here. I've been in the practice of law for the last almost 3 decades, so more or less I know how the civil and criminal justice systems work in the Philippines, and I think there are similarities between Hong Kong and the Philippines and even other countries. We are not really civil law or common law, but it's a combination of sorts. So anyway, I'm here to talk about the reforms the Supreme Court has been doing in the past, especially in the last 5 years. And mainly our problems are we have a heavy docket of courts of the cases, and it's kind of justice is grinding so slowly, and therefore many people are affected by it. And our Supreme Court has been doing a lot of changes. So here we have about 75 million people living in crowded cities, and to make it more accurate, we have 100 million all over the country. And it is no wonder that even our courts have been drowned with all sorts of cases. And then many of them have 1,000 or more cases in their dockets. That's all per court. I don't know how much in Hong Kong per court the dockets would be, but in the Philippines we have more than 1,000 per courtroom. And then they hear 30 to 60 cases a day, which means that's a lot of time and energy for the judge. So we need to do some innovations, and here, as you can see, our courtrooms, no matter how small or big they are, they're always packed, and parties have to be staying outside for their cases to be called by the court personnel. And then court session start normally or under the rules at about 8:30, and just to call the cases would last for about 1 hour and a half. And then each case would require some form of scrutiny and action, like for example, a postponement was filed or some kind of interlocutory order. Then that would only leave the court with 2 hours to try cases and hear the testimonies or of witnesses. So if 10 cases were ready for trial, the judge would be forced to give the parties in each case no more than 10 minutes. And that really is not enough. So as a result, piecemeal trials would take between 3 to 5 years, and then that would be more of the rule than the exception, and therefore delay is really part of our justice system. Now, you cannot blame the judges for such delay, and simply because of so many cases. And by the time he would have heard all the witnesses on the witness stand, it would have taken him 3 to 5 years, and most likely he would be unable to connect the testimonies of the witnesses, and would have to rely on the transcript of stenographic notes. Do you also have that here in Hong Kong?
You can pay for transcript notes, but it costs. So typically that the Hong Kong civil system is different. Rather than having a civil process which involves many hearings over a long period of time, Hong Kong adopts a common law system whereby you have one concentrated trial that runs from beginning to end until the whole case is heard. So an appointment is made for a case. Typically a case will last between 3 to 5 days. Time is booked, and that is the time allotted for the hearing of the case.
Oh, okay. So it's really more of a fast track system. All right. So it's really, again, it's even possible another judge would have to decide the case after hearing those testimonies, and then it will inflict injustice and even hopelessness to especially people who are aging. Some would even have died before they receive a decision, whether favorable or not. And that kind of system has also affected our country's, the outlook of foreign businessmen, because they're not sure really if their investments are protected, and if they go to court, how long it will take them to get a ruling. Now, litigation delays have many causes. Courts are few, and the cases are not proportionately distributed among the courts. And then there is a shortage in public prosecutors and attorneys. In fact, in Mindanao, where one of the speakers should have been a prosecutor, in one big province, there are only 2 prosecutors active. So really, let alone those prosecution cases, I mean, for him to investigate, he has to attend other cases in court. So there really is an acute shortage of prosecutors and attorneys. And our passing rate in the bar exams is only 20%. And that's high every year. So despite the shortage of attorneys, the Supreme Court has been very strict at least it has not moved so much. It has not been lenient towards the bar reviewees in the passing mark. And therefore, usually the delay in the cases would be attributed to the witness being on the witness stand, and this takes a lot of time, and you can imagine if you have 2,000 witnesses that will be waiting to be called in courts. Let's say for every case you have 2 witnesses, so you would have 2,000 witnesses to be heard by the, in the course of trial. Then that would be something literally, figuratively also a long way. Now, because of this, our Supreme Court has devised, and I think also Hong Kong has something similar to it, the Judicial Affidavit Rule. Before this came into effect, we have the direct examination in civil cases and criminal cases. So you would call in the witness, put him on the witness stand, and let him identify the document, tell him to narrate what happened. But that has been shortened, and now we have what we call the JAR, which requires the parties to disclose their evidence against each other early on, without holding trial yet. So before you go to trial, you will be compelled to submit your affidavits. How do you call that here in Hong Kong?
There can be affidavits.
Okay.
Typically for a trial, they're not in the form of affidavits. They're simply in the form of witness statements with a statement of truth at the very end, appended to the end of the witness statement.
All right. So now the direct examination has been dispensed with, and the witnesses must present to the court their judicial affidavits with the assistance, of course, of their respective counsel, and they have to attach all their documentary and object exhibits and have them identified, marked, and authenticated. So that X mark there tells you that there's no longer need for a direct examination, but your cross-examination still stands. So the effect eventually was that it has cut down the time of hearing cases to about 2/3, and now you just devote most of the time on the cross-examination. So these are not. This is not just the proposed rule, but it is now being followed. And in 2013, survey showed that 77% approved of the rule, and really this has helped a lot. Now, cross-examination is part and component of trial practice, and the only way to know if the witness is telling the truth of at least on what he has stated in his affidavit would be to cross-examine him. And this, the court has not denied the opposing counsel. But as you know, in cross-examination, you can ask leading questions, but not misleading. Is that the same rule here?
Yes, it's the same.
All right. So you can go direct to the point, and even the judge can ask any question to the witness. And but after the cross-examination, you may go to what we call the redirect examination, but this time it will no longer be dependent on the affidavits. All right. So now, how does
Let's just clarify, what exactly do you mean when you say redirect, in Hong Kong called re-examination? What do you mean by it will no longer be directed at the affidavits? What does that mean?
The cross-examination is supposed to ask the witness on matters that were in the what were contained in the affidavit. Now, when the witness clarifies these things in the cross, and the plaintiff's counsel needs to clarify further, the redirect questions will have to be focused on the cross-examination questions. He cannot just go back to matters that were contained in the affidavit, but were not touched in the cross. Is that clear? So
that's fine. There's the same rule here in Hong Kong.
And then after the redirect, you will have the recross. So the opposing counsel can again ask the witness on matters that were touched upon during the redirect.
I see. There's no recross in Hong Kong.
Oh, I see. So, but in the Philippines we have that recross, but it stops there. There's no more redirect, no more. All right. So now, before you are allowed to cross-examine, the rules compel the other party, the plaintiff's counsel, to submit copies of the affidavit before the hearing, and therefore the other party would not have any reason for seeking a postponement. Okay. So, in this kind of scenario, we have changed the rules of the game, because now the courts are more proactive, and it becomes a major player. Before, the court would just sit, the judge would sit down and then wait for the lawyers to argue and the witnesses to see what they want. This time, no more. The judge may rely on the affidavits and may ask directly the witnesses. But more importantly, the direct examination, which took so much time, has been taken out, and that the affidavits now have taken that course. Now, would the affidavit rule be applicable in criminal cases? Yes, very much so, especially for cases that are in the lower or lowest court or the first level. And then also in cases that are triable by a little bit higher court, and especially for claims for damages by the victim's heirs, because these normally under Philippine court system you cannot compromise a criminal case, but the civil component in the criminal case can be the subject of a compromise agreement, and this can be the subject of a judicial affidavit, but not the crime per se.
Right. Perhaps before we move from this slide, let's just clarify. METCs, I believe, are metropolitan trial courts.
Right.
MTCs are
municipal
trial courts. RTCs are regional trial courts.
That's right.
Now, just to make sure we all follow, what's the difference between a metropolitan trial court, a municipal trial court, and a regional trial court?
It's a good point, Professor. The metropolitan trial courts are found in the urban cities, big cities, while the municipal trial courts are found in the provinces. And the regional trial courts are courts of a higher level, and they handle cases that are not capable of pecuniary estimation. For example, annulment of marriages. Now, if it's for a simple collection of money, depends on the amount. If it's 400,000, you can go to the metropolitan trial court, but higher than that, you'll have to go to the regional trial court.
Right. Now we're focusing on this slide on criminal actions.
Right.
But you're talking about family cases, for instance, in the regional trial court.
That's right.
Are we to infer from this that the judicial affidavit rule also applies not just to civil cases, not just to criminal cases, but also to family cases? In fact, it applies across the board to any case.
That's right. That's true. That's true. Except for dissolution of marriages.
Except for the dissolution of marriages. Right. Now, dissolution of marriages, the Philippines is a Catholic country. Is that not dealt with by the Rota Romana? By the papal courts?
We have the canon courts and we have the civil courts. Canon courts' judgment are not conclusive upon civil courts. So you have to go to the church proceedings of annulment of your marriage, and at the same time, only if you want to get married again in church. But otherwise, you just have to be happy with a civil court judgment. All right. Now, what are the effects of the failure of the party to submit such affidavits? He should be deemed to have waived the submission. And of course, if you are deemed to have waived the submission of the affidavits, then you don't have any evidence, and the court will not have anything to appreciate in your favor. But the courts can be lenient by giving you one last chance, if the delay is for a valid reason and it would not unduly prejudice the opposing party. And of course, there's a fee that you have to pay, which is not less than 1,000, but no more than 5,000 at the discretion of the court. That is a typical office in a court building in the Philippines where you have to pay your docket fees. Okay, now we come to criminal cases. Having said that in civil cases, affidavits are allowed. Now, what is the impact of this in criminal cases? Of course, we don't want to see our loved ones detained, especially so, or in jails, especially when he has already served the minimum or sometimes the maximum of the penalty, and yet his case has not yet moved on. I don't know if this happens in Hong Kong, but in the Philippines, this is quite common, and therefore, the Supreme Court has taken steps to alleviate the problem. Not only in terms of the submission of affidavits, but in other respects, the Supreme Court has been very, very proactive. Why? As you will see later on, our jails are also congested just like our courts. So, those who are kept in detention jails are presumed innocent, all right? And then they suffer the worst fate of convicted felons in the national penitentiary. Now, our national penitentiary is a place where you have been convicted. Unfortunately, the paradox of it all, the national penitentiary has better accommodations than our detained respondents or accused. As you can see, this is a little bit special. It has more space. This is the Bilibid in Muntinlupa. This is a typical hospital, and they have recreation facilities. In the National Penitentiary, it is presumed that you have been convicted when you are placed there. But you can see you have sports facilities and recreation, no matter how modest it may be, and even have craft works for livelihood. But this is the city jail, practically subhuman conditions while you are awaiting for your cases to be tried. That's the biggest irony of it all. You are living in a very subhuman condition, and yet your case is still ongoing or has not yet commenced. A very typical scenario in city jails. And of course, this is a painful sight, especially for their loved ones. And therefore, the Supreme Court now has made some rules. In fact, the International Committee of the Red Cross has said that our justice system, the Philippines, is a party to the violation of the guarantees of due process because of the inhumane conditions. Now, our rules of in criminal procedure require the courts to fix a reasonable amount for bail. You also have that here?
Yes.
Okay. Before, it used to be that the Department of Justice has a schedule of bails for every crime. unfortunately, it was observed that only the rich sometimes, or most of the time, could afford bail. And the poor, whom you saw a while ago in the previous slides, could not afford to post bail, and therefore they languish in the city jail. So, the Supreme Court has devised a scheme where the Department of Justice, the recommendation of the DOJ in terms of bail is no longer controlling. But the courts are now made to be more proactive in determining how much bail really must be posted by the accused. So, in 2014, the Supreme Court came out with guidelines for decongesting holding jails by enforcing the right of the accused persons to bail and to speedy trial. All right? So, and then we also have this principle that whatever benefits the accused, you should give it to him. So, if, let us say, the bail is too high or excessive and could not be afforded by the accused, then the courts can lower the bail so that he can be set free temporarily while the case is ongoing. All right? And more significantly, the impact of that would be, again, to lessen the people inside the city jails. Now, the other thing that we have introduced now is usually penalties of minimum and maximum is in terms of jail term. So it has been the policy of the Supreme Court that, let's say, you have served the minimum jail term while you are in detention, your case is still being heard, you may be allowed temporary liberty. But you must sign an undertaking that you must appear in court where every time you are mandated to come to court. And a violation of that would mean...
Sorry, can I just go back one slide? If you didn't comment, but if I read it correctly, you were saying that if somebody was convicted of theft of 6,500 pesos, which is just over 1,000 Hong Kong dollars, they were subject to a minimum jail sentence, if imprisonment of 2 years, 4 months, up to 6 years. Is that right?
Yeah, that's an example given here. I'm sorry. Go ahead, please. Go ahead.
So, and so you have a minimum jail sentence that is linked to the amount, in this instance, that happens to be stolen.
Mm-hmm. Right.
I think
and the court has no discretion as to that.
No, when you would have served the minimum for the penalty of that offense.
But I mean, but say somebody stole 6,501 pesos, which is not a great deal of money. They have to be sent to prison for at least 2 years and 4 months.
I think the question is this. From your slide, the slide implies that if you've stolen, say, around 6,500 pesos, a little over 1,000 Hong Kong dollars, you need to go to jail for a pretty long period.
If convicted, right.
If convicted, given the amount that you've stolen.
Right.
That seems to be disproportionately long for the quantity stolen, only a little over 1,000 Hong Kong dollars.
That's the law. That's our revised penal code.
And now the question is, does the court have a discretion to overlook that minimum, or must the court apply the minimum?
The court must apply the minimum. We have what we call the indiscriminate sentence law. But if the accused has been detained for the minimum amount of time,
I think that is understood.
Right.
What is astonishing is that there should be such a, one might say, severe jail sentence for only the theft of a very small amount. In other words, you're talking about the congestion of the jails. It's no wonder the jails are congested if you've got such severe penalties for the theft of relatively nominal amounts.
That's true, Professor. That is why we also encourage plea bargaining. You also have that here?
But how is plea bargaining going to help?
Plea bargaining simply means that, let's say, you admit your guilt, then the court has the discretion to reduce the amount of your penalty, of the penalty.
Sorry, so if you plead
But if you go to trial-
if you plead guilty to a theft of 6,501 pesos, because you pled guilty, the court can then say, okay, we will give you a sentence lower than the minimum of 2 years, 4 months?
It's possible, because our revised penal code provides for mitigating circumstances.
Even
And-
of the minimum.
Yes, yes. That is before trial. But if you go to trial, you forfeit your plea bargaining benefit.
Right, so if you deny that you've stolen the money and you are convicted after trial, you go to prison for a minimum of 2 years, 4 months.
Yes.
On
if
6,501
you forfeit your,
pesos, right. But if you plead guilty, you can seek to bargain down that minimum term
yes,
to a lesser term.
yes,
To what kind of extent?
a few months.
Sorry, a few months.
Yes, that's right.
So there is a huge incentive on people to actually plead guilty and to seek to bargain down.
Correct. Especially for drug cases before. Before, if you were caught mere possession, you could, or rather selling, you could bargain for mere possession, but not anymore. But that was before. So your plea of guilty to a lesser offense would benefit you.
Sorry, where's the lesser offence?
Okay, selling of drugs.
I mean, the money I'm charged with theft of 6,501 pesos.
Let me just go back to the slide first. Hang on.
And without wishing to confuse matters, the other thing I wish to pick up on is that your judicial affidavits, if I understood you correctly, apply equally in criminal trials.
Mm-hmm.
And you said at the very beginning that those judicial affidavits have to state everything and hold nothing back.
Correct.
So you
Correct.
have to state your defence before the trial has commenced.
No, it's the prosecution which must present first the evidence, the affidavit. This is how it works in the Philippines.
Well, perhaps before we go that,
Okay.
let's do it systematically.
Sure. Yeah, right.
Let's do your first question. Let's get down to the bottom of the 2,500.
Here, you've just gone past it. Yeah.
6,500.
No, you just went past.
Back.
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 No, you keep going forward. Back. And then forward.
No.
Perhaps just use the mouse.
Why did you?
There.
There we
Yeah.
are. Okay. For example, the penalty for theft of 6,500 pesos is imprisonment from 2 years, 4 months, and 1 day to 6 years.
Right.
So there's the minimum, there's the
Maximum,
maximum.
right.
Now the question is this, you steal 6,500 pesos, you do not plea bargain, you say you deny guilt, you're found guilty, then the court has no choice but to impose the minimum imprisonment, at least of 2 years, 4 months, and 1 day. Is that right?
Right.
Next, you plea bargain. As a result of plea bargaining, then how much remission do you get?
Depends upon the court. It's discretionary.
Up to a certain, they can go below the minimum.
Taking the blood minimum,
Now,
right?
previously you,
Before trial.
well, yes, it's
Right.
got to be before trial, because by the time the trial begins, it's a little too late.
Too late, right?
Now, before trial, you plea bargain, you plead guilty, and therefore the court can reduce below the minimum, and previously you said it can reduce below the minimum by some months.
Months, right.
So we're only talking about a few months, is that right?
Right, that's right.
You're likely still to get 2 years imprisonment for stealing 6,500 pesos.
Could be, right. That's the penalty.
All right, on this point, do you have any further questions?
No, not on that. No.
Not on that point. All right, that's that point for the moment. We can come back. There'll be other time. We have lots of time for questions later.
So I apologize for interrupting.
That's all right. This is an more intimate audience, so we can feel free to interrupt at any given moment. Now, the next question. The judicial affidavit rule. Earlier slides indicate that at least in civil procedures, one must make full and frank disclosure of one's case. Is that right? In a civil case. In criminal cases, you say the judicial affidavit rule applies.
True.
Must the defense in its judicial affidavits give full and frank disclosure? If so, then before the trial, the defense would be, in effect, revealing its defense, its case for the defense, and that would normally be regarded as unfair here in Hong Kong. Here in Hong Kong, the defense is entitled to keep its defense up its sleeve, to first hear the prosecution, hear the prosecution's case, and only then, at trial, does the defense reveal its case. But you seem to be saying that under this judicial affidavit rule, the defense is required to reveal its defense very much at the beginning, before the trial has taken place, and before the prosecution has revealed its case.
All right, thank you for the
Can you
clarification.
just clarify?
The same system as in Hong Kong. The prosecution will have to present first its evidence in chief. All right?
But let's focus on judicial affidavits.
Right. The prosecution must submit its judicial affidavits and terminate its evidence in chief. The accused will not be mandated to present yet, not yet. Its judicial affidavits. The prosecution has to complete and finish its evidence in chief. In fact, if the defense feels that there is no evidence beyond reasonable doubt after the prosecution shall have presented its evidence, it can file a demurrer to evidence. And the court can grant the demurrer to evidence, and that is tantamount to a judgment on acquittal, and there can be no appeal. If the prosecution shall have terminated its presentation of evidence, only then will the accused now be compelled to present and submit its judicial affidavits. That is the same as in Hong Kong. You can hold back your evidence until the prosecution terminates its evidence.
Now, do you want to have a follow-up question? At this point, we can come back to it later.
Just mixing my 2 points up. At what stage would the plea bargaining come in? Could you seek to plea bargain after the prosecution case?
No more. In the Philippine court system, we have what we call the pre-trial before trial. So in the pre-trial, you can plea bargain. And only then will the court allow the plea bargaining to happen. After that, once trial commences, you can no longer be allowed to plea bargain.
Okay, a point of clarification. I got the distinct impression that as to civil cases, they could be drawn out with truncated evidence being called over a series of months or years, as you said it. Is that equally the case in the criminal system, or would the criminal system be much more condensed as to the actual trial?
It can be worse than civil cases.
So you could have one prosecution witness giving part evidence and then 6 months later coming back and completing his evidence.
Correct. Very true. It can even be years, especially if the witnesses are members of the military. They get assigned to provinces, to different areas, and when they come back, it can take them 1 year or 2 years. That is why criminal cases are have been getting more attention than civil cases now.
So forgive me for this, Professor, but why do you not actually seek to deal with a particular case, say to the prosecution, the defense, this case is going to be tried on the, whatever tomorrow's date is, the 6th of March. Everybody has to be here, and if it's not, the case will be heard in your absence. And then you just crack on and hear all the witnesses, certainly all the prosecution witnesses, until the prosecution evidence is concluded.
I was going into that.
Sorry.
We have what we call the provisional dismissal of cases. If after 2 years, in some cases, for lesser offense, 1 year, the prosecution is not able to commence trial or even continue trial, then the court can provisionally dismiss the case. And if after 2 years, the prosecution has not come back with a witness, it can lead to a final dismissal under our rules on speedy trial.
So that's 2 years after the trial was commenced.
Yes.
Jesus.
Or even after arraignment.
All right, we'll pause there
Yeah,
on your
sorry.
questions, and let's continue with Professor Ceballos' presentation, and then we'll come back with some questions.
Sorry.
Because you've got questions, I've got questions, I'm sure everyone else got questions, because from a Hong Kong point of view, there are a lot of strange things taking place here. But why don't you continue, Professor? And we're very sorry to have interrupted you,
No,
but
that's
it's
okay.
clarified where we are.
All right. We're now going to the right to speedy trial. This was your question a while ago where, let's say, the prosecution has failed to complete the presentation of evidence and the accused still is languishing in jail. So we have the right to speedy trial, and let's say the usual thing that happens would be the raffle of the case, 2 days from filing, arraignment, but these are all more of hornbook doctrines. This is the law, but it's never followed. So despite the law saying that trial should commence 30 days after pre-trial, actually, and trial should finish in 180 days, it never does happen. However, lately, a few months back, we have this new law called face-to-face trial. Now, at least in civil cases, the judge can make a ruling in 1 day. He will have all the parties called in his sala, and then hear all the versions, not just the testimony, but direct versions from the judges, and then make a ruling right then and there. It's a face-to-face trial.
That's for civil trials.
Right,
But
right.
let's focus on the criminal.
Okay.
What is the criminal?
In criminal, no, it's still the same. Only for tourists do we have that privilege. If you're a tourist in the Philippines, we have a law that expedites your trial in less than 2 weeks. There should be a ruling whether you should be set free or not, more or less. Only for tourists. So that we are trying to build up our image as a tourist hub. So if there are cases where tourists should be implicated in a crime, then the law mandates that there should be speedy trial.
Right.
All right. Now, well, the law was enacted in 1998, but only lately has it been invoked by so many accused. And the postponements of trial in criminal cases can be justified, especially by witnesses who are very material to the case but would not be located, and therefore you have a maximum of 3 dismissals or postponements. Okay, I'm sorry, based on that reason. Now, but you have to notify the accused or the prosecution of the provisional dismissal of the case. Now, we have a rule in our constitutional law that if the dismissal is provisional and it is with the consent of the accused, you cannot invoke double jeopardy. Or meaning to say, you cannot invoke delay, but there's a law now that guarantees you a 2-period allowed for dismissal, and thereafter, if you cannot still continue with the case, it's going to be a final dismissal. Okay? That's it.
Right. I think we have got a lot of questions
Go ahead.
to ask you, but I'm going to put you on hold first because there are other people here and they may have questions. If they don't, then you and I can shoot away. All right. At the back, do you have any questions you'd like to ask? We'll start with you.
I don't.
You don't. What about yourself?
Professor, also, I hold a degree from the Ateneo, and I'm curious how the actual practice has adopted these rules on the judicial affidavit, because when I did my practice a few months back, it seemed that even the senior partner of the law firm had the difficulty doing the judicial affidavit. So I'm wondering how it has really helped trial for the judges and how it has become easier for the practice.
Right, we will just clarify a few points in your question just to make sure we understand your question. First, perhaps we might just identify who you are. You say you've done practice. You've been a previous student at Ateneo, just out of curiosity. Have you been Professor Ceballos' student? No, unfortunately.
I'm a PhD student here. My name's Angela. And I also did my LLM here.
And you say you've done practice.
Yes.
What sort of practice?
I've worked for the Supreme Court, and then when I came back for a few months, I did private practice, general practice, almost everything, including trial.
Right. And now you're talking about civil trials.
Civil and criminal.
And you're saying that the law firm that you worked in had difficulty with the judicial affidavits. Can you explain what difficulties you're having in mind?
Because if I understand the concept of judicial
Well,
affidavit.
what difficulties did your law firm encounter?
First they were asking me to make like a list of questions that I would be propounding on the client and her witnesses, and then we were supposed to answer it. It was supposed to be if I got the partner's instructions correctly and if he understood the rule correctly. It was supposed to be like the actual testimony, reduced to an affidavit. And it was very difficult because he was telling me that everything should be straightforward. There shouldn't be any leading questions or leading answers on the part of the client. Everything should be clear. But after I came up with the affidavit, the partner was actually telling me that I think this forecloses other arguments for us, for the defense or for the prosecution, for the criminal, for the civil cases.
So your complaint is that the judicial affidavit system is artificial.
No, really. My question is, how does practice actually happen with the judicial affidavit? Has it really helped to speed up trial? Has it made things difficult for the practice, or?
It has become more difficult for the law firms. I'm one of them.
Yes.
Why so? I have to gather all my witnesses in my office, draft all the affidavits, attach all the documents, and have them signed, and submit them all to the court in one go, which never happened before. Before the affidavit rule came in, I would call you as my first witness, invite you to my office, tell you what to say in court, at least the truth, and then I would have to wait for the next 6 months for my next witness, but not anymore. I have to get all the material witnesses to come to my office, make the affidavit in question and answer in a straightforward manner, but only the ultimate facts. Now, probably your partner was a little bit apprehensive on foreclosing some arguments. You're not supposed to argue in your affidavit. You're not supposed to put conclusions of law or legal arguments, no. Only facts as they happened and supported by evidence. That's all. So, one witness should be corroborated by other witnesses on the same matter. But really, it is no joke to make affidavits for one case, especially if you have so many caseloads in your law firm. And that takes a lot of our time. But what can you do? Now, in terms of the court, I've seen this with my own experience that a lot of times the direct examination takes so much material time. And courts with so many dockets would only give us 20 minutes maximum to hold direct examination. And that's hardly enough. So it happens that in some cases, there would be 3 court settings for one direct examination. But with the affidavit rule, you submit that in court before trial, you furnish the other party a copy, and if there are any objections to the affidavit, from being hearsay, from being inconclusive, the other party can make a manifestation in court to have them stricken off the record. And then, I don't know if you're aware, attorney, but before the cross-examination, the witness will have to make an offer of evidence.
You have to tell the court the purpose of the affidavit that you're presenting and what facts. So if those facts are not in the affidavit, all right, then you're barred from presenting those facts in any form. Unless by a stroke of bad luck by the other party, he cross-examines him on that point, and you give him an opening to be asked on those points in the redirect. But the rule is, you cannot ask anything in cross that is not touched upon in the direct.
All right, we'll pause there. Do you have any follow-up question?
How effective has it been for the caseload of the judges? Would you have an idea?
I heard from statistics from the Supreme Court, it has been effective, especially for pilot cases at pilot courts at that time. And even now, especially for civil cases. Because if you've been to trial attorney in the Philippines, there's so much time wasted in the direct examination. So I think this has helped tremendously the court dockets.
Thank you.
Do you have a follow-up?
No more.
All right. You mentioned pilot courts. What do you mean by pilot courts?
All right. Usually, when we have a new law, like the face-to-face court system now, we don't apply it to all courts right away. We try to test the waters with other courts. Let's say in Makati, we have three regional trial courts adopting that kind of system. And then later on, if it succeeds and we get all the comments with them, we perfect the system, it now becomes applicable to all cases. So, I mean to all courts. So we have pilot courts that are being subjected to new rules by the Supreme Court.
Now, do you have any questions?
I do have one question, at least. I am loath to go back to the same point that we discussed.
You shouldn't feel any qualms.
Right.
We're going to go back there, I'm sure.
Okay.
Many times.
Let me try and find it. Right.
Well, while you're trying to find it, why don't I give you an opportunity to slip in your question? Perhaps you might identify who you are
Nicholas Miller.
and your
I am more, sorry.
just what you do,
I'm a solicitor.
solicitor. And your question?
I have a few, I mean, they don't necessarily follow on from the last question.
That's all right.
Professor. One of the things about judicial affidavits, Professor, and it's obvious that the lawyers, and you said that the law firms are having difficulties, which languages do they have to be written in? And I ask this because I have an involvement with two families in the Philippines that come from the same province, but they don't speak the same language. So is it in Tagalog, is it in English, is it in the native language of the particular deponent of the affidavit, or what?
It can be in the dialect, but it has to be translated into English or Filipino.
At whose cost?
Your cost, unfortunately.
Including criminal trials?
Well, in criminal cases, actually the prosecution has the burden to translate, I mean to put that in affidavit form. Now, have you ever appeared in the Philippine courts? Not yet.
I'm sorry, say
Have you ever appeared in Philippine courts?
I've never been in a Philippine court. No.
All right. This is how it goes. Let's say I speak a native tongue, not English, not Filipino. There is a court interpreter who will translate my dialect, my answer, my dialect in English or Filipino. But most likely it will be in English because that is the common practice and easier to transcribe for court stenographers. So, even if, let's say, you put that in the local dialect, the court has an interpreter for cross-examination purposes, to interpret or translate the questions to the local dialect, understandable to the witness. Is that clear?
Yeah, when they're giving evidence, what about the judicial affidavits?
The judicial affidavit, you can put that in your local dialect, but it has to be translated also into English or Filipino.
Yeah, I'm sorry, I followed that, but what about the other way around, the prosecution's affidavits?
Same rule, same rule. But if you have to ask, if you don't understand the dialect, understandably because you're not from there, the court has the duty to get an interpreter to translate your English into the local dialect.
Right. So, plea bargaining can reduce the sentence at the court's discretion, and you've mentioned that that can only take place before the trial has started. Now, does that mean we're to assume that one cannot change their plea mid-case?
No. I have not heard of a case where the crime or the plea has been reduced after plea bargaining.
No, perhaps plea bargaining is the wrong reference to be making. But once the affidavit has been submitted, then you have locked in essentially your plea. You said either I am, I plead guilty or I'm innocent. But in some criminal cases, certainly in the UK, you can change your plea halfway through the trial, should you decide it.
Not in the Philippines, but what I can tell you is a practical situation. Criminal cases are not supposed to be compromised, meaning to say it's a crime against the state. But if there is a civil component, a money component, once the complainant has been paid, he does not care anymore about the criminal aspect. So what do litigation lawyers do? We let him sign an affidavit of desistance that he is no longer interested to pursue the case, and that most likely there was a misunderstanding of the facts. Now, if Professor Reyes was the accused or was the private complainant, he will be put on the witness stand. And the judge will ask him, Mr. Reyes, do you confirm your affidavit of desistance that there was a misunderstanding between you and the complainant or the accused? Yes. So the civil aspect at least will now be separated. And what will likely happen is that he will no longer come back to court, and the prosecution will not present any witness anymore because he is the star witness. And for failure to prosecute for so many months or so many years, the court will now render a final dismissal.
Sorry.
I'm not quite sure that the question has been answered. The question is there anything in principle to prevent a person from changing one's plea? You've filed your judicial affidavit by way of defense. You've decided there whether you're going to plead guilty or not guilty. The trial then proceeds with the oral examination of witnesses, this time on the part of the defense, adduced by the defense. You then, as the defendant, decide that you want to change your plea at that point. You say you've not encountered any case, but that doesn't actually answer the question. The question is, can you do so?
You cannot.
You can't.
You can't. Now, do you want to follow up?
Not with a question. No,
Well, you have a comment, I think.
No, it's fine.
Can I
Yes.
comment? So it means therefore that if somebody having heard the evidence says, okay, in my parlance, you've got me banged to rights, I'm going to plead guilty, you, the court, turn around and say, you cannot change your plea, and therefore the whole trial has to continue as though that man is pleading not guilty.
Yes.
But isn't that a huge waste of time? I mean, whether or not you give a discount on his sentence due to the late change of guilty, but if he suddenly turns around and says, I want to plead guilty because you've covered all the, you've connected all the dots, and you say, no, you cannot.
All right. Is it a plea of guilty or not guilty?
Well, it was originally not guilty, and it becomes guilty.
Oh, I'm sorry. I thought your question was to a plea bargaining to a lesser offense or what?
No,
No.
It's simply you filed a judicial affidavit. You obviously reveal your case there in the judicial affidavit as
Not
by way of
guilty.
defense, including whether you're saying you're pleading guilty or not guilty. You say in your judicial affidavit, I'm not guilty for the following evidence. You then adduce your evidence, and then at some point you say, well, what's the point? I'm going to throw in the towel. I'm going to change my plea to guilty. You're saying that can't be done.
Oh, I'm sorry. I was referring to a plea of guilty to a lesser offense. You cannot do that
Right.
once trial has commenced. But you can plead guilty even if trial has commenced.
Right.
But the court will not stop there. The court is obliged to continue asking searching questions, not exactly to go to trial. And the court will ask you, do you fully understand or understood your plea of guilty? Yes, I do. All right. Then the court will ask you questions based on the prosecution's evidence. If really you confirm this, then if you confirm, then the court will render judgment. I thought a while ago was plea for lesser offense.
So even after a signed affidavit?
Yeah,
After-
sure. You're guilty. Most likely, the court will 100% appreciate the evidence for the prosecution and rule against you.
Is that not perjury?
Sorry?
Is that not perjury?
Well, there is. In fact, even the lawyer can be disbarred for that. But,
So there are huge disincentives to changing your plea.
yeah. I mean, that's why I told you I have not heard of a person pleading guilty. I mean, again, I'm telling you, I haven't heard of a person pleading guilty after pleading not guilty.
Right. Now, do you have any follow-up that you'd like?
No, I think
Your
that's
turn
answered
now.
it.
If there was a plea of a lesser to a lesser offence, let's stick with your 6,500. So you might be able to bargain and say, I will plead guilty to theft of 5,000 pesos or 3,000 pesos, but not 6,500. What would be the situation then?
The amount, the amount of the amount involved would correspond to the penalty of imprisonment, or vice versa. So let's say in this example.
Well, it might take us a little while to find the example. I think we can follow. Just state the example.
Yeah. So please repeat your question.
I think the question is this: if you say plea bargain and you say I plead guilty
For lesser offense, lesser amount.
6,500, well, you're facing 2 years, 4 months, and a day. So you say, well, I plead guilty to stealing less than 6,500. I'm prepared to plead guilty to stealing, say, 5,000 pesos. Can I do that in order to avoid having to get a minimum of, say, 2 years or more in my sentence?
No, you can do that for a lesser offense of the imprisonment, but the amount of money will be what you plead guilty, because the court allows or compels you to restitute the amount stolen, apart from the imprisonment. There is a penalty, there is a sentence for you to go to prison for lesser amount, for lesser time, because you pleaded guilty. But if you pleaded guilty to 5,000,
And I'm not sure you have understood the question. The question is this: the charge is stealing 6,500 pesos. I say, well, I'm prepared. I meet you, prosecutor. I'm prepared to plead guilty to a charge of stealing 4,000 pesos. Would you be able to accept that?
The 4,000, you'll have to be, you're pleading guilty, right? Okay,
But only to 4,000.
all right. Your 4,000, the court will ask you to pay him,
No problem.
all right? But the penalty for the imprisonment can be lowered because of your plea of guilty,
I think
of a
that's
mitigating circumstance.
That's what you're getting at, right?
Yes. Yeah.
So there would be advantage to me to saying, well, would you be prepared to accept a plea of 4,000? I get a lower
Yeah,
penalty,
it's being done.
detention penalty, and here's 4,000. I'm prepared to restitute, to use your word, the 4,000. That's possible.
It's possible.
Right. Okay, following on from that, the restitution, is it made through the court or is it dealt directly to the complainant? If I'm accused of, you're the judge, and I'm accused of stealing 6,500 pesos from Professor Reyes, and I want to say, okay, I will plead guilty to stealing 4,000 pesos from him because that's all I think his biros are worth or whatever it may be. But I'm actually willing to give him restitution of 6,500 if I have to. So the consequence of that, as I understand it, is one, I would be accepted as treated guilty as if I'd stolen 4,000 pesos, so I would get less than 2 years, 4 months. But secondly, in making the restitution, do I make restitution directly to Professor Reyes or to you, sir, as the representative of the court?
To him directly.
So doesn't that open up a two-sided coin, which is that Professor Reyes, I'm sure he wouldn't, but can say, okay, Miller, you can make restitution to me, but not of 6,500. I actually want restitution of 10,000 pesos. And what happens if I say, well, no, sorry, I stole 6,500 from you. Here's your 6,500, but I'm not paying you the extra 10,000, the extra 3,500.
It's being done. It's being done.
So what happens?
Then you have to pay whatever he wants because he is the complainant. And he will not sign the affidavit of desistance if you don't satisfy him. Can I cite to you a clear example?
So in other words, once I'm accused of theft, if I want to reduce my prison sentence in the event I'm going to be convicted, and I accept I've stolen a bunch of biros or apples or whatever from him, or a cabana of rice or something, I'm then completely vulnerable to his demands for restitution, which may not be related to the amount that I'm supposed to have stolen.
Isn't the analysis a
Possible.
little bit different?
Very possible.
But isn't the analysis a little bit different? There's the criminal case and there's the civil case. From what you've said, it's possible to plea bargain for the state, for the prosecution to accept a plea of guilty for a lesser amount, 4,000 in our example. That may deal with the criminal case. I'll be sentenced accordingly. I would have to make restitution to the victim, 4,000.
As part of the criminal case.
As part of the criminal case. But the victim may still feel that the victim has a civil case for a greater amount, that insufficient restitution.
No,
and therefore,
sorry, forgive me, that's not the point I'm making. My point is sticking purely on the criminal side. Because my understanding was that if restitution was made within the criminal proceedings, Professor Reyes could opt to say, okay, it's a misunderstanding, I have been compensated. And then the whole case may be dismissed. Or alternatively, if he chooses not to say it was a misunderstanding that Miller actually did steal these goods, right? But he acknowledges that he has been compensated, I can use, the restitution has been made. Miller can then use the fact of that restitution to say, look, I have given restitution, I have admitted my guilt at an early stage, I wish to plea bargain down from 2 years, 4 months. So we have two options, is that right?
right.
And it depends in part on the goodwill or the honesty of Professor Reyes as to which of those options is followed. And it also follows that if Professor Reyes is not on a score of goodwill and demands 10,000 or 100,000 pesos, I can't even make restitution to him because he says, I'm not willing to accept your 6,000. Is that the situation?
Yeah. And you can make, if you have to make a plea of bargain, and the court will accept that, I mean, with the prosecution, wait for the court judgment, and the court will only say 6,000. That's all. He has no choice but to accept that. Because that's the amount involved.
But I thought you said I had to make restitution direct to him and deal with him.
Okay, this is what I was saying a while ago. You could make a deal with him, especially after plea bargaining. Make a deal with him, and we do this in court. The amount was only 6,000. Okay, it's too late to plea bargain. Mr. Reyes, I'll pay you 10,000. Don't appeal in court anymore, because the prosecution does not have any witnesses anymore. So I pay him 10,000. He gets away, and after so many years, does not come back. The case can be dismissed for lack of prosecution or for failure to prosecute. Because you cannot actually compromise or totally obliterate the criminal side. You can only plea bargain, but not totally obliterate. Is that clear? Because Reyes wants more than 6,000. I give you 10,000.
I think what Mr. Miller's complaint is whether or not the criminal case is resolved depends a lot on my goodwill.
Yeah.
Effectively.
If it's the court that approves the plea bargain, and only 6,000 was involved, you're limited to 6,000.
So the court would have a role in it.
Sure, of course. Always.
I think
Okay.
what Mr. Miller was suggesting is I could hold out, blackmail, and say I'm not
No.
going to play ball
No.
unless I get a lot more money.
No.
Right.
For plea bargaining, I mean before trial.
Plea bargaining, it's effectively the state and the court that decide whether
Right.
the plea bargaining is successful.
And the amount, you're limited to the amount in the information or the charge sheet.
All right?
So I say, look, I've offered him 6,500. He won't accept it. He wants more. And you say, okay, where's the 6,500? I put the 6,500 on your desk in front of him, and you pick it up and give it him, and then that's the restitution.
Is it as a result of plea bargaining?
It's a very simplistic way of doing it. I mean, paying to court and all the rest of it, no doubt. But the principle is that in the event that Professor Reyes resists the attempted restitution, I can invoke the court, and the court would stand in, take the restitution, and hand it over.
Yeah, the court will never accept your 6,500, will order you to pay 6,500.
All right. I think we've exhausted this
I
question
think so.
for a while, and I think it's obscuring the fact that the case, that the talk, the seminar is really about criminal justice reform generally, as opposed to a simple case. My main impression is that the reforms are rather tepid. That the reforms are not going to be very successful because they're not really going to clear up congestion in the jails. They're not going to clear up clogged lists. All they are just going to take off maybe a little bit here, a little bit there, but really the reforms are hardly very bold, hardly very exciting. Say, take the civil case, what I'm more familiar with, to say that people should put in witness statements saying exactly what their case is long before trial is held, so that there are no surprises at trial. What's so difficult about that? And yet it seems from the question earlier and your answer that this is such a revolutionary new system that lots of lawyers are feeling it's very difficult to comply with this. So if this is the situation now, we're not going to have any real reforms. What would you say?
There will be. In fact, it's only a matter of getting used to it. The lawyers in the Philippines were never used to affidavits. Never. Even during my time. And up to now, I gather my lawyers, all the witnesses, because we have a deadline to meet and submit all the documents and affidavits. I think it's only a matter of time that we will get used to it. You know, every change has resistance. And I fully subscribe to the affidavit rule because it cuts down on the direct examination time. Really, we spend a lot of time direct examining a witness. And so if we can just do away with that, the judge can already see what the facts are based on the affidavit. Actually, the affidavit is just a repetition of the complaint. But what's more important now is you can see what the defendant is trying to say under oath.
Right now, is it going to be replaced? Direct examination, you say, takes time. You have these judicial affidavits. Then time will be taken by motions left, right, and center to strike out bits of the judicial affidavit as contrary to the hearsay rule or contrary to this or that evidential rule. And so all it will lead to is a multiplication of motions to strike out, delete, ignore various parts of the judicial affidavit.
That's part of the democratic system, filing motions, especially if they are based on hearsay or inadmissibility rules. But still in all, I think there's a good side to the affidavit rule.
Now we go back finally to what Mr. Miller was asking at the very beginning. Why couldn't we just have, say, in the criminal case, a trial that takes place from day one to whenever it's finished, straight through? Why do we have to have it truncated in bits and bits that can run for years and years? Why can't we just have one day in, or whatever period of time in court, the trial begins and it runs until it ends? What's so difficult about that?
The practical side of it is, let's say the court has 1,000 cases. It will be unfair for other cases who have fallen in line not to be heard by the court in that particular hearing. So the court apportions the time for every hearing, for every case, 20 minutes maximum, because there are so many caseloads. Really, I would like to see that one of these days, what you want is what you want is what I want. Let's say we have a continuing mandatory trial, but it has never happened. It has never happened. Even the massacres, Ampatuan, it will take probably my lifetime. I will never see the end of it. And that the government even created a special court. The court will not hear any other cases except that criminal case. Have you heard of the Ampatuan massacre? More than 100 people died or so. A special court was created, but with so many interlocutory orders, motions, and whatever you have under our court system, I don't think I can see that it will be finished.
Now, is the problem essentially, at the end of the day, a shortage of manpower? There are just not enough judges.
Budgetary.
And it's budgetary at the end of the day. There's just not enough money.
The judiciary takes a very small percentage of the national budget.
So, forgive me though, but you said that your government is seeking to encourage tourism and so on by expediting, saying that tourists shall be dealt with, criminal cases shall be dealt with in 2 weeks. So you are quite capable of prioritising cases, and to deal within 2 weeks, the system must be able to deal with the case, well, within those 2 weeks, presumably by setting aside a day to deal with the allegation of theft against me. So if that's the case, why in principle cannot the court system prioritise other cases? So we start off with mass murder, then we start off with simple murders, then we start off with I don't know, serious bodily harm or rapes or things like that, and work your way down. Why does each case have to be truncated? On a completely separate case, I can't remember the name of the accused, or can't pronounce it, but from Mindanao, who was responsible for murdering all the journalists and the supporters.
Ampatuan.
Sorry.
Ampatuan.
Yeah. You know, why cannot that just be dealt with? Bring them up and try them.
They are. In fact, that court was created or was assigned to handle only the case.
But nothing's happened.
No, it's moving slowly. They have changed so many lawyers. Let's say there are 20 accused or so. One accused is entitled to a lawyer, and every lawyer is entitled to cross-examine the witness. It takes so much time.
Yeah, but with the greatest respect, I mean, forgive me, Professor Reyes, I know I'm going off
Probably.
reviewing it, but I mean, 20 years ago when I was involved in a particular province in the Philippines, it was common knowledge that if you wanted somebody shot and you're a Filipino, you could go and pay the local sergeant of police 50,000 pesos, which at the time was quite a lot of money, and he would personally do it. He wouldn't delegate. So with the mass murderers and the money they've got, why haven't you... I mean, several witnesses in that case have been already disappeared. Can I put it like that? Surely expedition of dealing with criminal cases will lead to fairness and justice, which was one of the comments you made before at the very beginning. That's what was the aim of the reforms.
I'm sure Professor Ceballos doesn't disagree with that. The nature of the system in the Philippines at the moment is such that I'm afraid, with the best will in the world, Professor Ceballos, yourself, probably nothing is going to happen for some time.
I'm sure, forgive me.
I'm not sure
just
that there is
ranting.
any
My
easy
apologies.
answer.
I'm sorry, I'm just ranting.
I understand. So I think we shall conclude this evening's. Yes, Angela.
Professor Ceballos mentioned something about the interlocutory orders in the Maguindanao massacre. I was just wondering how big a role does ethics in the private practice play in all the scheme of the judiciary's backlog?
What can you just clarify what you mean by the question? It's too general.
Do you think there's something wrong with the ethics of the private practitioners in terms of the habit of filing all these interlocutory orders?
Interlocutory orders, interlocutory
Yes,
motions.
Yes, the motions. And there's a habit of going up to the Court of Appeals and the Supreme Court.
Too many motions,
Yes.
too much technicality.
Don't blame it on ethics. Blame it on the court system, on democracy. It's democracy at work. Like every lawyer feels, I have the right to file a motion. I have the right to be heard not only by the lower court, but by the two appellate courts. And I'm supposed to exhaust all the remedies that I can to benefit and to protect my client. So it's not a matter of ethics. I think it's more of the system at work.
It's also common knowledge that a lot of these appeals going up to the CA and going up to the Supreme Court, most of them are denied at the Court of Appeals, but then a lot of private practitioners would choose to bring it up again to the Supreme Court. So there's a lag time of, say, for this Court of Appeals, it's at least 1 year, and 2 years for the Supreme Court. So it's technically a delay of 3 years for the trial court.
There can be no delay if, let us say, there is no issuance of an injunction. Remember,
Perhaps I will stop there before we get bogged down in technicalities ourselves. I think I'm going to conclude tonight's discussion. It's been quite interesting. We've given Professor Ceballos quite a difficult time. We've interrogated him, cross-examined him, recross-examined him, etc. And he's still pretty cool around about 6:30 in the evening. We thank him for that, and we thank the audience for their participation. Thank you very much.